It's an extraordinary story in this morning's Sunday Telegraph reporting an interview with the Justice Secretary, Lord Chancellor and Deputy Prime Minister Dominic Raab. I've linked to the article on Twitter and set out some thoughts there, and I thought I'd just record this short video to expand a little bit on that. So the headline in the article is that Raab is to revamp the Human Rights Act to avoid Strasbourg, meaning the European Court of Human Rights, dictating. So what should we take from this, and what might its constitutional implications be? Well, there are 3 points that I just want to really highlight. First, and this doesn't really have anything to do with the Human Rights Act directly, the article seems to suggest that the government is now thinking about reopening the question of judicial review reform. Those of you who have been following this debate will recall that the government established an independent review of administrative law, giving it very broad terms of reference, which appeared to contemplate some really far-reaching changes to judicial review, which is the means by which courts can oversee the legality of what the government does. In spite of those very broad terms of reference, the independent group who conducted the review did not sort of take the bait, and they proposed some pretty modest reforms. The government seemed to regret that, and again put forward the possibility of wider changes in its response to the review, but in the end, the legislation now going through Parliament is really quite modest in this regard. In the article in the Telegraph, however, the Justice Secretary seems to envisage that this will be reopened, referring to the fact that courts are making decisions that the government finds unpalatable in relation to matters such as infrastructure projects. Now, the government suggesting reform or further reform to judicial review is not in itself problematic. Judicial review isn't perfect, and there's no inherently right balance between executive and legislative autonomy on the one hand and judicial oversight on the other. But we should be concerned if the government is suggesting that it wants to reduce the court's judicial review powers simply because courts make decisions that it finds uncomfortable. After all, the government's willingness to accept discomfort is a prerequisite in a rule of law-based democracy. Governing should sometimes be difficult. Sometimes it should be difficult because the law imposes requirements and limitations that the government finds unwelcome. And for the government simply to try to reduce judicial oversight in the light of that kind of concern is problematic from a constitutional perspective. Second, Dominic Raab says that we want the UK Supreme Court to have the last word, not the Strasbourg Court, not the European Court of Human Rights. Now, a week ago, there was an article again in the Sunday Telegraph suggesting that the government was heading for a clash with the courts in relation to the Northern Ireland Protocol. The implication appeared to be that the government would consider legislating to enable it to essentially get out of some of its obligations in relation to the Northern Ireland Protocol because it now regrets having entered into them. It may well be that that doesn't happen, but the ultimate point here is that the suggestion was that the government could somehow legislate its way out of or around its international obligations. And a similar point now seems to be being made in relation to the European Convention on Human Rights. So the European Convention on Human Rights is the international treaty to which the Human Rights Act gives effect in domestic law. And under the European Convention on Human Rights, the UK has agreed to abide by certain basic human rights standards. Article 46 of the Convention requires the UK to abide by the judgments of the Strasbourg Court. So the problem here is that if the UK government were to get Parliament to enact legislation somehow saying that we don't have to abide by the Strasbourg Court's judgments, or that we can ignore those judgments if the Supreme Court disagrees with them, the difficulty is that that wouldn't change the position in international law. If the UK government really objects to being bound by the judgment of the Strasbourg court, its only option, its only respectable option, would be to actually leave the European Convention system. Now, that's a step that many people would regret, but it would at least be intellectually honest. It would be saying, well, we don't think that this is a suitable arrangement for the UK, but rather than erect this smokescreen of saying that somehow we can legislate domestically to leave behind international commitments that still bind us in international law, that's a much more dishonest way of doing this. So the bottom line is that while the UK is a member of the European Convention system, we are bound by it, and we are bound by the judgment of the Strasbourg court, and saying that things are different in the UK because Parliament is sovereign or because we've passed legislation that somehow gets us out of these obligations, that simply makes no sense as a matter of international law. And it isn't a position that any state that wants to be part of and to be treated as part of a rules-based international order can respectably claim for itself. Thirdly, Dominic Raab says that he wants to protect Parliament from judicial legislation abroad or indeed at home. So now the true scope of this seems to become clear. The objection isn't just to so-called foreign judges interfering. It's an objection to judges interfering. But what do we mean here? What does the Justice Secretary seem to have in mind here when we talk about interference? Well, when we drill down, essentially, interference seems to mean courts doing things, courts interpreting the law in a way that the government doesn't like. Now, there's no constitutional problem, whether viewed from the point of view of the separation of powers or the rule of law, if Parliament legislates to change the law. If it wants to secure an outcome, for example, that's different from a current piece of legislation as that has been interpreted by the courts. It would be a problem if Parliament tried to do that retrospectively, because that would then raise a profound rule of law concern about legal certainty. But as long as Parliament changes the law prospectively, there's no inherent problem in that. But it seems, on reading this article, that the Justice Secretary is in fact suggesting going further. He says that he wants a mechanism to allow the government to introduce ad hoc legislation to correct court judgments that ministers consider to be incorrect. Now, it's already open to Parliament to legislate whenever it wants. So what beyond that is in contemplation here? It may be that what's being proposed is that ministers should have broad powers to make secondary legislation, that is, legislation that they can make without going through Parliament itself, so that ministers themselves can correct court judgments. If that is what's in contemplation, then that is profoundly problematic. Indeed, it turns constitutional principle on its head. In a different context, the Supreme Court in the Evans case said of a power allowing ministers to veto judicial decisions under the Freedom of Information Act that it would undermine fundamental aspects of the rule of law. It said that allowing a minister to overrule the decision of the judiciary merely because he doesn't agree with it would not merely be unique in the laws of the UK, it would cut across fundamental principles that are fundamental components of the rule of law. Now, it isn't clear if Dominic Raab's proposal would go this far, or whether it would be limited to prospectively correcting interpretations of legislation that ministers don't like. But a ministerial power to do this would itself be deeply troubling. It would reassign a basic judicial role, interpreting the law, to ministers. Ultimately, this all strikes me as part of a project to enhance executive supremacy by treating courts, whether foreign or domestic, as unwelcome interlopers. And yet, all of this masquerades as an attempt to protect Parliament. The reality of this executive power project, as we might call it, is that it would be the executive that was the principal beneficiary of such changes, and the loser would be basic standards of good governance.